We are not on the record yet. I just wanted to introduce myself. I'll stand up to make sure everyone can hear me. My name is Michelle Phillips. I'm an administrative law judge with New York State Department of Public Service. I've been assigned as the presiding examiner for this particular matter that's been submitted by the applicant, a request for their proposal to build a wind farm in the towns of Parishville and Hopkinton. What we're doing today is the pre-application conference, so it's not going to be a public statement hearing. It's focused specifically on those requests for funding that were submitted. We currently have 4 of those. I'm just waiting until the 5 o'clock hour to start because that's the time for which this meeting was noticed. So I'm going to give everyone an opportunity to get here by that time. But in the meantime, I just wanted to ask if you have any electronic devices or anything that might ring or buzz or make a noise, if you could silence it. If you can't hear me, let me know, and I'll try to raise my voice and make sure that you can hear everything that's being said. Also wanted to give my associate examiner the opportunity to introduce himself as well.
Good evening. My name is Daniel O'Connell. I'm from the Department of Environmental Conservation. I'm the associate examiner assigned to this matter.
Yes.
Yes.
You said the purpose of today's meeting was relative to the intervenor funding.
Yes.
The public notice on this also talked about the initiation of the stipulation process.
Yes.
That's also.
Yes, we'll discuss that as well.
If for some reason someone from the back rows needs to speak, maybe they could come forward.
Well, for the most part, it's going to be the people who provided, made a request for intervenor funds, and I believe they're all represented now at the front of the table, at least one of their representatives. I have someone from CCRP, the towns, and PHA. And those are the 4 that we have, as well as the applicant. We'll be speaking as well. So it's now 5 o'clock. Let's please go on record. I call case 16F0268, application of Atlantic Wind LLC for a certificate of environmental compatibility and public need pursuant to Article 10 for construction of the North Ridge Wind Energy Project in the towns of Parishville and Hopkinton, St. Lawrence County. My name is Michelle Phillips. I am an administrative law judge at the Department of Public Service. I have been assigned as the presiding examiner in this proceeding.
My name is Daniel O'Connell from the DEC Office of Hearings and Mediation Services. I'm the associate examiner assigned to this matter.
I just want to explain a little bit about the process. We have a court reporter here. He has set up microphones so that we can create an official transcript of the activities that occur here today. That is the reason why I have the people who have filed requests for intervenor funding and the applicants sitting at the front tables so that their statements can be captured accurately. This is not a public statement hearing, so we won't be taking general statements from the public at this time. There is a process for that on our DMM, or the Document Matter Management System. What I will do now is go through and ask some questions about the funding requests that were submitted. I also will talk a little bit more about the process, just some general rules, because we are trying to capture and create an official transcript. I did ask that everyone silence electronic devices. I will also ask that people speak one at a time. Please try to speak clearly, and please be courteous and respectful. I have been monitoring the comments, so I know that there is a lot of emotion and people have very strong feelings around the issues that this type of proceeding raises. But I do ask if we could all be courteous and respectful. We don't have to agree with one another, but if we can just listen and be courteous, that would be appreciated. Yes.
Excuse me, Judge Phillips, can you explain to all of us the underlying reason for all the information you're looking for? In other words, we who have applied for intervenor funds, we are seeking to furnish information on several topics. Why do you want that? Can you explain, in other words, the paradigm, the context of all of this? Because it's going to influence what people say.
I'm not sure in terms
Okay,
of what you mean
let
what
me help
people
you
say,
out.
but, well,
Sure.
let me try to answer your question.
Well, maybe
We
let me
have
clarify my question a little further. I was a professor at Rutgers University for decades. When we judged people's credentials coming up for promotion and tenure, we always looked at their information to ask, is this a contribution to knowledge? I believe that's the purpose, actually, of all the Article 10 process. Is this, each step of the way, is this a contribution to knowledge? Your knowledge, the citing board, and so on. Is that correct?
It's designed to create an adequate record on which the citing board can make an informed decision. However, there are two different steps. Right now, we are in what's called the pre-application stage. So this is not the stage when you would actually make your arguments about the application. We don't have an application yet. It's not the stage where you would be providing testimony. It's not the stage where we're holding hearings yet. This stage is designed for a very specific purpose, and it's set forth in both the regulations and the statutes that are available on the citing board webpage, as was explained in the notice of this proceeding, or this pre-hearing or pre-application conference. It's designed to allow people to review what's called a PSS, and it's that big binder that's back in the box of what the applicant has detailed they intend to put forth in support of their application to build these wind turbines and go forward with this proposal. Let me finish. What you have right here is an opportunity to review that document, see whether or not there are issues that you disagree with them about in terms of how they decide they intend to go forward with respect to the scope of their studies, the methodology that will be reflected in their application. But we're not yet at the stage where there will be cross-examination, hearing, testimony. So what we're looking at right now, and the reason why you're asked for the information that you're asked for, is that there are overarching regulations and guidelines that I have to adhere to in reviewing your request. Those were set forth in the statute and then were further refined in the application. I don't have leeway to tell you that you can ignore a statute or a regulation. So
we're talking past each other.
All
What
right.
did I apply for money for? For 4 issues. I'm not going to enumerate them. So did everyone else here. We have issues that we applied for funds for, correct?
Yep.
So those issues presumably are being presented to you folks and the citing board to help you make your decision. What are the big issues in this community? That's why I applied for money, and everyone else here did as well. Am I correct in that? So it's a contribution to your knowledge and the community's
Not
knowledge.
at this stage, though. I don't think you are hearing me. The way that it's been set up, and it's not me. If you look at the statute, there are 2 different parts of it. So this part is designed to ensure that when and if they do come in with an application, because an application doesn't always come out of the process, but when and if they do, you will have had an opportunity to say, okay, you're saying you want to do a 5-mile study area. This is the reason why we think maybe you should consider a 10-mile study area or area of potential impact. It's really designed to try to get the best possible application when you get to that point. So we're not yet at the point of challenging what they said in the PSS, or the preliminary scoping statement. And I'll try not to use acronyms, but sometimes I get caught up. So it's just it's a slightly different focus at this stage. It's trying to reach agreement, if possible, as to what they should be putting in their application, how they should create and procure that information and present it, so that if they do come in with an application, maybe you narrow the scope of the issues that you disagree on. So, for example, what if you all agreed, yes, that they should definitely comply with the local laws that they've been revised, and you come up with a stipulation? All that means is that then they'll do it that way in the application, and we won't have to have days or hours or whatever, a cross-examination about that issue. But you may still you may not reach a stipulation on a different issue, say noise, or how they treat wetlands, or there are myriad issues, and I'm not going to try to name all of them.
So is
They're
that
in the
something we
PSS.
will debate here?
No, you won't.
Ah.
That's what I'm trying to
Okay.
explain. We're solely here to see, did you follow the regulations when you put together your intervenor funding application? Did you identify relevant issues? Are you asking for money for purposes that are consistent with the preliminary scoping portion of this proceeding? So, for example, if you ask for funding for participating in the hearing, that's premature, and I can't award money for that right now. That's not what this pot of dollars is for. That's what we're doing here today. So I do have some clarifying questions. This is my opportunity to perhaps either ask you some questions that will help me and my co-examiner reach a decision about how to equitably provide funding for people who have expressed an interest in being involved in the pre-application scoping process and review of that document, and perhaps participating in stipulations. That's what we're here for today. Did I respond to you?
Oh, that's good, yeah, thank you.
Okay.
I wanted everyone to hear this.
Okay.
Thanks.
So normally what I would have done next is made sure that we took appearances, so I'm going to do that. What I'm looking for are, we have, and I guess maybe I'll jump to this stage. So normally at the application stage, there's a statutory provision that lays out who the parties are. Who are the parties to this type of proceeding? Because we're not yet at that stage, we do have a party list. Being on the party list at this stage, though, just means that it's an easy way to identify the people who have expressed an interest. We have not yet made any determination, though, or confirmed whether or not you actually qualify for party status. That will come later at the application stage. But in the meantime, if you do have an interest in this proceeding, if you want to participate in the stipulations process, if you want to be notified, if you know that you eventually want to be considered or request party status, you should fill out what's called a notice of intent. The directions are available for that on the Siting Board webpage. So that becomes a very easy way to identify those people who have expressed an interest in participating in this stage of the proceeding. However, it does not guarantee that when we get to the point where we actually make the determination about party status, again, looking at whether or not you comply with the statutory requirements that are set forth, you should be granted status as a party. We haven't made that determination yet. So being on the party list at this stage doesn't necessarily mean that you're a party, and it's without prejudice to anyone to stand up at a later point and say, I
Okay.
don't think this person qualifies for party status, and here's why.
Yeah, Andrea.
Hi.
I'm trying to hook up with Andrea Cherubin
Okay.
from, hi, Andrea. No.
All right, so if we could please take appearances, and that means if you have filed a request for party status and you're present, if you could identify yourself for the record. We'll start here and move across.
Robert Panache and Laura Bamier on behalf of the applicant, Atlantic Wind LLC, from the law firm of Young Summer.
Brian Sinsbaugh from the law firm of Curtin Law Firm, Casanova, New York, on behalf of Concerned Citizens for Rural Preservation.
Roger Linden, attorney for the towns of Hopkinton and Parishville, the firm of Capello and Linden.
Bernard Molesky, consulting attorney to Roger Linden, town attorney, and to the town.
Calvin Martin, representing the Parishville Hopkinton Alliance.
Hi.
Dean Long, Department of Public Service, Environmental Compliance and Certification.
Is there a way you can silence that?
Yeah, well, we're just trying to connect, and it, you know, just doesn't want to connect.
Can you turn the volume down?
Yep.
Christopher Balk, representing DEC, Region 6, Bureau of Habitat.
Matthew Brower, Environmental Analyst for the Department of Agriculture and Markets.
Is there anyone from Department of Health by any chance? Or Adirondack Park Association? I know that the town supervisor for Parishville is present. Hi. Is Susan Woods? Hi. Nice to meet you. Thank you. So I think I've already explained the purpose of this conference, but again, I'll just note that on May 17th, there was a notice issued indicating that we would have a conference in this matter to address requests for intervenor funding that had been filed. The requests for funding were due, I believe, on June 19th. I want to note that we did receive 4 such requests. Parties have already identified themselves, so I'll try to avoid being repetitive. This is not a public statement hearing. This is an opportunity for us to go through those requests, ask some questions about them. We'll give people an opportunity to be heard if they have concerns or objections with respect to any of the requests that have been submitted. I have mentioned several times the siting board webpage. Hopefully everyone is familiar with that, the location of that, and the information that's there. On that webpage, there's detailed information about what should be contained in an intervenor funding request, including a guide as to what should be in there. So, for example, we start off with any Article 10 applicant being required to provide funds that will be used to cover certain expenses that are incurred by municipal and local parties. And that's for participation in the pre-application scoping process. And later we'll have a different one for the Article 10 application process, assuming that we get there. Not all interveners are eligible for intervenor funds. By statute, it's only municipal and local parties. With respect to those parties, the presiding examiner, that's me, has to reserve at least 50% of those funds of the potential awards and funding for municipalities, and local parties are eligible for up to 50% of the funds. I've already talked a little bit about the fact that we'll be using the term party. For now, it's a term of convenience. If you have any additional questions or want to understand that better, there's some correspondence from the Secretary to the Siting Board dated November 23rd, 2016 that goes through like what the categories are and the fact that for now we're using that as a term of convenience. Placement on that party list is at this stage without prejudice to the ability of other parties to object to your request. So again, getting back to funding, the purposes or the services for which you could use that funding when it's awarded are limited. As I said, it has to be for this phase of the proceeding. So that's reviewing the PSS and negotiation of stipulations concerning the scope and method to be used in application-related studies. We have a fund, again, this is set by statute, of $35,000 in this particular proceeding for the pre-application phase. We have 4 requests, however, that seek 50% of the fund, which means that the amount requested is greater than the amount that's available, pretty much by a factor of 2. So, we have looked through the requests. I do have some questions. I'm going to go through them in the order that I received the applications, which means that I will be starting with the town. I want to note that they did originally file ahead of time on June 16th, and there was some information or clarification that I did ask for that was then provided, I believe, on the 14th or 15th. What I generally do is look to see, are you an eligible party? So for the municipalities, they are affected by this proposal, they are eligible as a municipal party. So I don't have any questions about that. However, in going through the request, there were a few things that caused me to either question whether the scope of services that had been identified were properly limited to this portion of the proceeding. And for example, on page, they're denoted RFIF, and then a number, which means request for funds, intervenor funding, page 3. For example, it did mention hearings during the Article 10 process. It also mentioned, with respect to Mr. Maluski, am I saying that correctly, that you had already assisted the township with the provision of an analysis of Article 10, substantive law and procedure. So I just, again, wanted to note that, for example, working on revising the local laws is not necessarily related to the review of the PSS. To the extent you're talking about hearings, we don't have hearings in the PSS stage. So that seems a little bit overbroad. If you looked at the requirements for a funding request, the last one is a copy of a proposed or actual contract with your individual league. That was one of the things I asked for clarification because the town did not have one for their town attorney. That has since been provided, but I noted that the breadth of that seemed to possibly go beyond the pre-act stage as well. So I did have some concerns about that. Also, I just wanted to clarify, the towns each asked for half of the funding. So I'm understanding that to mean you really wanted the whole pot of funding. I'm not sure that that's an equitable distribution when you have more parties other than the municipalities requesting that funding. I also wanted clarification on what that meant in terms of your expectations for billing, for example. With respect to the attorneys, you have 2 attorneys. How will you ensure that there's no unnecessary overlap or duplication of your efforts? Have you sort of discussed that? Can you speak to that a little bit more?
Well, we are both here at this pre-hearing today. It was my intention not to charge either of the towns for my appearance here today. It's come to me, and I'm very much being for his services. By and large, the reviews of the PSS that was submitted, that was done by Mr. Maluski. Very little of my time is attributable to that, and I did not bill onto the towns very much for my time, other than taking the first draft and Mr. Maluski from our comments, and he was making and just reworking it a bit. And perhaps an hour might be. Again, it's what I'll put into the towns.
So when you submit your bills to the town, you bill town of Parishville 50% and town of Hopkinton 50%?
Unless there's something, when it comes to, for example, our comments with regard to the PSS, yes, that was done. If there are joint meetings with town officials, et cetera, it's done in that manner as well. 50% each of the 2 towns, based on my time. If there are things that are particular or peculiar to one town, the exclusion of the other, then I think.
And was the town, I guess, the towns then each are requesting separate awards, and I'm assuming you still want them split half. So it wasn't based on the number of turbines in each town. It's just whatever is awarded, you're requesting half to one town and half to the other town.
Essentially, at this stage, the PSS stage of these proceedings, the work is going to be pretty symmetrical for each respective of their children's impact.
Okay.
If I could, just to address your concern about the billings, I won't be, and have not been billing the towns directly. I am supervised or directed by Mr. Linden. I bill Mr. Linden, then bill to the town. So there's a built-in control mechanism to ensure that we don't have overlap.
And I guess I wanted to know for the town supervisors, I want to make sure you sort of understand how this process works. With respect to intervenor funding, money is not dispersed until after we receive invoices and reports. It's our expectation that the town supervisors will each be reviewing these vouchers and making sure that the charges are proper and accurate, and then submitting those. There's also a reporting requirement for the town. I wanted to make sure that you're aware of that. And again, all of this is set forth in the regulations. I also just wanted to note, it says right in the statute as well, that funding cannot be used to appeal citing board decisions or other court-related actions. And I just bring that up because I did know there was some wording, I believe, in one of the retainer agreements about litigation. And you meant, I'm assuming, the administrative litigation, but I want to make that clear.
That is a standard retainer letter that is used by attorneys throughout the state of New York, and it's meant to be intentionally fraudulent.
Okay. That's what I assumed, but I just wanted to make sure because I know that towns have a lot on their plate, and I just want to make sure everyone's clear on what the parameters are. You can only seek reimbursement for the expenses that are authorized in our ruling. You cannot be necessarily bound by your retainer agreement, for example, because it does go beyond where we are at this point in terms of it being review of the PSS and participating in the stipulations, negotiations. And also, we generally do not allow for expenses that predate the filing of the PSS. So that's, I believe, May 4th.
Can the people speaking try to speak up a little bit because we're not hearing anything?
Okay. She just asked if the people in front could speak up and respond so that they can hear you. So I don't have any additional questions about the town application. I do want to move on to the next one that I received, which was for a group called Parishville Hopkinton Alliance that was submitted by Calvin Luther Martin. So this is not an instance of a municipal party, obviously. This is you ask for funding as an eligible group local party. So one of the first things that I do when I get these requests is look to see if there's such an entity on our party list. There's no request for party status for an entity called the Parishville Hopkinton Alliance. So I looked then to your list of members, and I don't. So I looked to the list of people that you included, and it wasn't complete. I didn't go through all of them because it wasn't clear to me that everyone necessarily was a resident that fell within the, we look for, are they a resident and do they dwell, are they actually affected? And a lot of times we look to the 5-mile radius that's mentioned in the statute.
Did you read the prefatory paragraph above their names or actually in the RFIF? It explains that.
Where you say they're 18 or over living in Parishville, Hopkinton, right. I'm just noting for you though that in order, I have to first verify that you're an eligible local party, and that means the resident is affected within the 5 mile
The
radius.
answer is yes.
So you,
Yes.
well, it appeared that some of the people were not within that 5 mile radius. I'm not going to, I guess.
Can I,
vote.
want me to speak to that further, or no?
Not yet, because there were some other issues as well. As I explained before, this scope, this part of the proceeding is a very limited scope. It's review with the PSS and participate in the stipulation process. And when I looked through what you said, in almost every instance, it seemed to be describing activities that seemed more suited to the application phase. For example, you have documentation about infrasound, and again, I'm not saying these are not valid issues, but I have to look to see whether or not it's focused on reviewing the PSS.
I have to see, I can't hear you, see whether or not what?
It's focused on reviewing the PSS.
It is indeed.
It's not the, right, except it's not worded that way.
How was it worded?
You prepared it, correct?
Yeah, but I don't recall, it's not in front of me.
Okay. So you referred to Mr. James having given expert testimony. He's been documenting infrasound in homes and communities. These are their qualifications. But when it gets to specifically what they would be providing, detailed statement of service, and I'm on page 5 now. He will critique the applicant's health and noise plan based on measurements of wind. He'll explain the unique and distinctive nature of turbines. Mr. Wayland was going to analyze bird and bat surveys. Mr. McCann was going to use professional appraisal guidelines. Dr. Pierpont would elaborate further on turbine health effects. No, I couldn't find any statement of where they were going to review and participate in the review the PSS.
You've read their PSS. The PSS brings up all of those issues.
Yes, and I'm not saying they're not relevant issues, but again, it's not written as if you are going to have them review and participate in the stipulations. That may have been your intent.
Yeah.
Okay, can you show me where in this document it says that they're going to review the PSS and participate in the stipulations?
It says they're going to address those issues in the PSS. Does it not?
No, I didn't see it. It's in there. I'm not.
May I look at that?
Yes. And while you're looking, there was another issue as well. As I said, and I think it also, well, I know that it also says in the intervenor funding guidance document that when you apply for funds, a request for intervenor funds must contain 9 things, the last of which is a copy of a contract or proposed contract or agreement with the expert witnesses that we want to hire. That also was missing. It seemed like that would have been fairly easy to provide because you said you had emails with the individuals, but I don't have them. So those were some concerns that I have with that application. I do want to move on because I'm treating the local parties sort of together because that's kind of how it's divided in the regulation. So
Mr. James will critique the applicant's health and noise claims in their PSS.
Does it say in their PSS?
It doesn't need to. That's the whole point of it. It's a PSS. That's what he's obviously going to critique. And it's
not a critique, though. At this point, obviously he should review it and
noise and health claims.
I'm sorry, we're talking over each other.
Sure.
Finish. I'm sorry.
He's going to address their noise and health claims. Wygand is going to address their bird and bat claims. Dr. Pierpont, right there, is going to address their health claims in their PSS. I think it's pretty obvious.
Okay, I still do not have contracts, though. So those are...
For $4,000 each of them is just going to write a statement. 10, 15, 20 pages, and I give them $4,000. That's pretty standard. Maybe not in this venue, but in the academic world, yes.
That may be. However, when you have an intervenor funding guidance document and you have regulations which say what you must provide and you don't provide it, you put me in a situation where I can't approve it.
Right.
That's the problem. So I'm just noting some of the issues. I also have to look at all of the requests. Right now I have requests for more money than what we have available.
Okay.
So I'm trying to look and see, number one, have you met the qualifications? Have you provided the information that was requested? Are you focused on the types of services and activities that are at issue at this particular stage of the proceeding? So that's what I'm looking at.
And then I assume, I gather you're answering.
Can I just have that?
The answer is no, we didn't do that.
Correct. That's
Okay,
what
so
I was
we
explaining.
cut out of the running there?
Let me finish.
Jim did send his document over.
I don't know who's speaking.
But you would be the speaker.
So I want to confirm CCRP.
I mean, with us, are we out of the running then?
I believe you are.
Okay, thank you.
But I don't want you to leave.
I will leave.
Okay, so can I ask, are you at all interested in participating in the stipulations process?
I don't know.
I'm sorry?
I don't know. I don't know that there's much purpose to it, frankly.
Okay. It would be helpful to know who the applicant should be notified.
Sure.
Do you want to be notified of the stipulations processes?
I'd like to remain on the party list.
Okay.
So will it be announced there?
I'm going to ask actually the applicant to explain a little. I did want actually some more information about how you intend to conduct the stipulations processes.
Well, to start, we're going to send out a notice. We want to send out a notice to, on the party list to those that want to provide, meaningful contributions towards, what stipulations will help the process move forward. So within that, we were to send a notice that included, what list of topics each party, if you put it, party wanted to include as something for their topic. We wanted to try to come up with a streamlined process so that we can have, again, meaningful conversations with the interested agencies and with parties.
Meaning people who filed a notice of
Correct, yes.
Were the stipulations meetings, are they going to be in person, by phone? How are you intending to conduct them?
I suppose it depends. We are willing to have in-person conferences. We're willing to allow those to, attend by phone. That is what is needed to make it more efficient. But I think what we want to ensure is that we have, meaningful conversations with those that are willing to work towards studies that need to help us towards the application process.
Just so you know, it's my expectation that you'll be more inclusive. You keep saying meaningful conversation, and this is an area where people differ in terms of their positions. So I don't want that to be code for only if they say they're, I don't know. I just want to be clear that it should be more inclusive. If a person has expressed an interest in participating in that process, I want them to receive notice.
That's
I believe you said you wanted notice, correct? Notice of the stipulation, correct? If there are going to be stipulation conferences, I thought you said you did want notice.
Yes,
You're still on the party
But
list.
he posts a notice on the DMN? I mean, how does the notice get circulated?
I think it's usually circulated by email, but is that what you plan?
Yes, that was our.
To everyone on the party list? I'm on there.
Yes.
So I will
Yes.
find out. And then I have to reply to you people to get permission to be an interviewer?
No, no. We won't address party status until an application is filed.
Okay.
So you're on the party list for now.
Yeah.
That's, as I said, without prejudice to anyone coming in. And once the application is filed, if it's filed and we move forward, we'll have a procedural conference, and that will be one of the issues.
And if I wish to participate, I can contact you people and say I would like to?
No, you don't need to contact me. No, because you're on the list. So there's a whole process that's set forth. When assuming that there are stipulations that are negotiated, they have to go through their notice provision. Whenever they file something, it goes to everybody in the party list, everyone on the, you know, we'll do a notice that they've come in. That goes to everyone on the service list, so you don't even have to be on the party list. If you're on the service list, you'll find out those things if you've asked for it.
But when you put together a group of people to discuss the stipulations, right? When that
No,
group
that's
is
what
put
we were
together-
trying to clarify. It's going to be the people on the party list.
Right.
I've asked them to be more inclusive, not less inclusive. So it should include, at a minimum, the people who are on the party list.
Okay. How do we get to this magical position of being on the party list? Let's simplify it.
There are two different phases. I think I've said this. There's a pre-app phase.
I've read the whole thing many times as a PhD. I'm a smart guy. I got that.
Okay. I would refer you then to the Secretary's November 23rd letter. This has been covered, and I think it's on the CMM. I would ask you to read that, and if you still have questions about who's the party and when this happens, then you can contact.
Okay. Thank you.
However, you're free to leave, but obviously. However, one of the other things that is set forth in the regulations is encouraging parties, local parties, to maybe consolidate their efforts. And I noticed before CCRP sort of modified their request, you both were asking for the same experts, and I'm assuming some of the same.
Yes, we had a bigger group. They've got Richard James.
Okay.
We have Richard James and three others.
Remember at the beginning I asked if we could all speak one at a time. I wasn't quite through. What I wanted to say is under the statute, it encourages consolidation of parties who have similar interests. And it seemed to me that the fact that you had both identified pretty much the same people that you wanted to hire, that there might be an opportunity for that. And what I wanted to know is whether or not you are amenable to considering working with the other local group to maybe have those issues addressed and sort of unifying your efforts and working together.
Indeed.
Okay.
Thank you.
Thank you.
I'm sorry, just wanted to ask, is there still the opportunity?
Can you identify yourself?
Yes, I'm sorry, I'm Tom Whitesell, I live next door in Potsdam.
Okay.
Is there still the opportunity for Dr. Martin to complete the process of the application for intervening funding on behalf of the Parishville Hopkinton Alliance? Or is that deadline defined by this meeting right here?
It will likely be defined by the end of this meeting. I mean, with him leaving, it sort of shuts the door in terms of us having any additional dialogue or seeing whether or not he wants to talk to the representatives of CCRP and perhaps do that. So my plan right now is to just continue with the questions that I had on their application. I was hoping that we might actually take a recess and perhaps see whether or not we couldn't establish something like that now, but I don't think that it doesn't seem that will happen today.
That's a really good idea. I'm his wife, I'm Dr. Nina Pierpont. He's not leaving as long as I'm here. I sat here so I could answer questions and make decisions on his behalf. But if you want to take a break and I can go out
Well,
and talk to him.
I still have one party that I want to ask questions of. So I highlighted some of the issues that I had with that particular application. It did not read to me as a PSS type application. I know he wanted me to make that leap, but when we have a situation where there are more requests than we have funds available, I do have to read things pretty tightly. But I don't, if at all possible, I would love to have everyone be able to participate and have their interests addressed. And it seemed like there would be a great opportunity for some perhaps consolidation of interest between the PHA and perhaps CCRP. Can I come back to your question after I ask the questions of this application?
Well, I whispered you.
I'm sorry. I will come back to you after I finish asking questions of this particular applicant, if that's all right.
Well, it has to do with it. I belong to both groups, basically.
Are you Janice?
No, this is
Hi.
Janice. I'm
Hi.
Ann. But our aim is, yes, to get all these experts in
You
here.
belong to both groups, you said? What's your name again?
Ann Britton.
Ann Britton. Okay, so let me speak with your representative. And
Yeah,
because
we do want to work together, and we can get the experts a lot cheaper, so we can get all 4 of them rather than just the sound one, because we've done work for them. So.
Okay, but you have 2 representatives apparently, right? She's a member of your group
If
as
she's
well?
a member of CCRP, then yes.
All right, so let me just turn to, I did have some questions with yours as well. I wanted to clarify though that.
She's not on the list of the people that we do have.
We intend to cooperate with your group.
I'm sorry, who are you?
I'm with the CCRP.
Okay,
And
so you have a representative. I'd like to talk to him and ask him questions. Thank you. What I wanted to clarify first, before months ago, you sent me something yesterday. I believe you called a revised request and you wanted me to work on that.
The revisions,
Correct?
if you would, yes.
The second
I would
one?
appreciate that.
Okay. So, June 26th, some of the same concerns, but you may have kind of jumped the gun because generally, I mean, I'm not trying to make this difficult for people, but I do have certain things that I have to look for in this application. And so, again, I start by looking, are you a local party? Are you one of the people eligible for funding? I was actually comfortable, comfortable. So I received your initial application, and it wasn't clear to me who was in the group. So what I did was I went to DMM, and I looked for the name of your co-chair and your secretary, because they had provided information. And just based on my sort of rough estimate of looking at figure 2 in the PSS, which has that 5-mile study area and the addresses that they provided, I was fairly comfortable determining for myself that they appeared to reside at dwellings that were within that 5-mile radius. And I wanted you to confirm for me that my understanding was correct. The residences that are listed for the co-chair and the secretary, do those fall within that 5-mile study area? Do you know?
To my understanding, I believe that they do, being within the towns, the 2 towns, respectively, town of Parishville. I did provide a later document also that has the specific addresses.
Right, but I got this yesterday.
Yeah, I
There's
do.
no way I was going through 91 names,
It was
typing them in and then comparing it to figure 2. So I was just explaining that I think you need like at least one person that would qualify as a local party, a local person, a resident. And I wanted to just confirm that at least those 2 people are residents they reside within that 5-mile study area, so that it's consistent with the statutory requirements and the regulations. So on that basis, I was comfortable, I think, determining that your group qualifies as a local party. And you'll have to, so I did notice, and I'll just confirm with you, it appeared that you made changes to the statement of the number of persons that you're representing. This is 1A, is that correct? I'm just trying to understand how it was different from the first one.
Yeah, that's correct. So in the first, and it was pointed out by the applicant that we had supporters and members.
Yes.
I limited this down to only members, so that's
Okay.
the reduction.
The next change that I noted was 3B on page 3. You seem to change that response as well, is that correct?
That is correct. It was reduced as a result of the changes in the scope of the work that was going to be performed. Because of the limited scope that is now being requested for funding, that is why that change was reduced down to 19,000.
Okay. And the same is true for 4A, I'm assuming. That was the next change. And then you also changed 4B. I think that was where you had named some of the other experts that the PHA had identified, correct?
Yep, that is correct. So in 4B, we previously had listed some additional experts that were going to possibly provide services. Because that we were trying to limit this and streamline, essentially, primary focus is on the noise in this portion, and that's where we felt we needed the expert services. For that reason, we took the others out for this stage, possibly later in the stage, but that's not relevant here.
Okay. Did you speak with Mr. Wagen? Am I pronouncing his name correctly at all? Because he responded, I believe, to the applicant, and from his response, it sounded like perhaps he was interested in providing services during the stipulation, this PSS/stipulation stage. Can you speak to that at all?
I believe we're trying. I'll have to speak to Mr. Reed.
That's Calvin. That's one of them, Calvin.
Right, he's your representative, so he's speaking for it? No?
I get it.
Wait, sorry.
That was in this, I guess, spoke earlier about having reviewed the list. She's not on the list of the members that we did
Okay,
provide.
so
But
Ms. Britton, correct? You're with PHA? Okay. So I just want to
Right, well,
get
that's
some additional information
that's
from
what
Mr.
you-
Sensabaugh right now. Did I say your name
yeah,
correctly?
so he was previously on our list. Again, we're looking at focus. I have not spoken with him, but based upon his response, to be quite honest, I didn't see the response walking this meeting yet from him.
Okay.
That's provided.
that-
Well, here, I have a copy for you. Take mine.
And while, just because I think it's on point, Dr. Pearson, did you speak with Mr. Wiggins at all on behalf of PHA or?
No.
No.
Calvin.
Okay.
Calvin.
Thank you.
Calvin did.
Thank you. So,
You may hang on to it.
What did you mean by that question?
I was trying to determine, I'm trying to figure out the reasonableness of the request and whether or not there was room to maybe provide funding for an additional expert if the parties are willing to work together. And it seems like Mr. Martin had maybe more detailed discussions with Mr. Wagen. It wasn't clear to me. From the letter that he submitted, Mr. Wagen submitted in response to the applicant, it made it sound like he did understand that there are these two different pieces, and that he perhaps wanted to participate for either your party, PHA, and I have to remember this is going to be in writing, not so, or CCRP. So I was just trying to figure out if, in fact, that was the case, because it also seemed like the amounts at issue were a little bit different in both applications for at least one of the same people. So I was wondering if there was any room there to perhaps have other areas of interest covered. For example, Mr. Wagen's specialty and Mr. James' specialty, as well as the legal fees that you requested. That's what I'm trying to get at, and I think that's where it would have been helpful perhaps for the two parties to talk, figure out if there is that kind of room, if there is a way to get more bang for your buck, basically, and to cover a broader area of issues. So that
Does it clarify which experts the two parties are asking for?
Well, that's the other complication. In the revised version of the CCRP request, they're no longer requesting funds for Mr. Wagen, but initially, both PHA and CCRP identified all of the same people with the exception of yourself. So they identified Mr. McCann, I believe, Mr. Wagen, Mr. James, also the attorney, I guess, was the difference. So it just looked like there was some room there to maybe work together and cover more than just noise. And I don't mean to diminish noise, I shouldn't have said more than just noise, but maybe have someone participating for the local party, a local group type party, who can cover an issue. Mr. Wagon, I believe, was his specialty again? Yes, environmental. So you'd have someone participating in the stipulations process who can address environmental issues, and someone who could address noise issues, as well as the legal counsel that your party desired. I know that PHA did not desire legal counsel, or didn't request funds for legal counsel.
Did not, and if a unified expert list could be Mr. James, Mr. Wygand, and Mr. McCann, that would be great. I certainly don't need to be in that list.
Yeah, the only thing is basically, if I do it 50-50, so 50% municipal and 50% to the local party, I'm not sure there's enough unless there was some wiggle room. And it sounded like your husband had negotiated perhaps a different rate than CCRP had. That's what I'm trying to figure out. And I think it may be best if perhaps you talk or not, I don't know. That's what I'm trying to figure out, is how to maybe have these limited funds cover a little bit broader topic areas.
Certainly, I understand, and I think the differences in cost that we're seeing right now is, I'd spoken with Mr. James in terms of his cost, and this is a cost based upon Mr. James and what he would do as opposed to a straight split amongst the different experts that would be. So I think that's where the variation does come in.
Right.
He does have a wide variation in terms of what he's looking at,
Mm-hmm.
and I believe he said he could stay at the lower end, so that could still stay around that 4,000 area, which was previously stated in their application as well.
Can you speak to me about travel then for the attorney? Because initially I was thinking that the stipulations were probably mostly going to be perhaps email or phone and not as much travel, because that might create a little bit of more room.
Certainly, and that's actually something I had written down, as we mentioned, is having a phone conference available. I'm here today to be in person, obviously. I think this is something that should be done in person initially,
Yes.
just to make some face contact and to understand the different parties and be able to meet different parties. But moving forward, I think that travel can certainly be minimized, especially the fact that we're coming from such a far distance, and that expense could be reduced.
So those were the questions that I had.
I know, thank you.
What I will do now, because I know the applicant and obviously any other party who is here can be heard on this issue as well. Do you wish to be heard on any of the requests for settlement?
No, Your Honor. One of the biggest concerns we had was we just weren't sure that they qualified as a local party. And I believe we've heard from the CCRP people that they have two people that are located within the town. So we're willing to.
Well, that was actually me. I looked at the two people based on the original application. I believe they're saying that they have more than two people who are registered, but
We can't. I mean, one of the things I wrote down, I just can't tell. I just don't know whether they're a local party or not. That's really up to you to decide. And then I think I'll wait. One of the concerns I had is over the stipulations process, which I think we can wait for. But my only question or comment was just making sure that they're a local party.
so I think we would like to take just a short recess to discuss this amongst ourselves before we respond to the request. I don't know if the local parties would like, do you want to perhaps talk for like 5 or 10 minutes, or have you basically provided us with all of the information that we think is relevant?
I know that we have covered a bulk of the information. I know that it has been discussed in passing. So at least initially, when we had the same experts trying to work together, I think, in all due respect, it seems from parents tonight of how difficult that may be. And I don't know if there's any way that there could be assurance that if these were, I know that there would be a judgment order put out for the intervention funding and enforcement of that, of trying to make sure that the parties work together and trying to have a unified group, because I don't want to hold back the applicant. I don't want to hinder the process in any way. I want to make this as quick and efficient as possible. So I don't know if there's any way that there would be a way to assure that should the parties not be willing to work together for whatever reason, that there would be someone to go back to, whether it be Secretary Burgess or anyone on the board. If we're to agree to receive funding together, I want to make sure that both groups have equal say to either of the experts in terms of they have communication lines and things that are going to move along effectively.
I guess I wouldn't necessarily get involved in that, but I would encourage perhaps the local parties and the people who are interested, because the other thing I guess I noticed as well, there were some people that appeared to be more that were on both lists or both groups. You had identified some of the same experts, so it seems like one of those opportunities for which the statute was written, which allows you to encourage you to consolidate your interests.
Certainly. I'm not trying to waste resources.
No, I know. And I wasn't suggesting that, but things move quickly, and maybe people just didn't have an opportunity to talk, and I just wanted to broach that to see if there was that possibility. So I guess I'd like to, based on everything that we've heard, we're going to take just a short, maybe 5 to 10 minutes, perhaps, to discuss what we've heard and make a decision. Then we will talk next, I guess, about the stipulations process a little bit more.
Can I make one short statement?
Thank you. You raised about 3 or 5 questions about the being a request by the towns. We only discussed a couple of them. I just want to mention a couple of other considerations with regard to your questions. And just by way of reminder that the county of St. Lawrence has endorsed the town's request.
Yes, I did see that.
And is supportive of the towns, and also recognizes in their letter that the funding is limited, as you've repeatedly said and accurately said. The second is that the revisions of the regulations, it's a unique situation in the sense.
Local laws or regulations?
Local laws. And the unique situation in which the PSS was submitted before as the local laws were being revised, as everyone has acknowledged, including the PSC staff. So part of our function in advising the towns was to ensure that they understood the difference between procedural and substantive matters with regard to how the signing board process considers those as going forward in Article 10. So there is some relevance in smoothing the process and ensuring that the substance of the town's ordinances is fully considered. And last but not least,
I'm not sure. Can you elaborate on that? I'm not sure I follow what you mean.
Sure. There are issues, procedural issues. The town needed to understand that procedural issues are, for the most part, irrelevant to the Article 10 process, whereas the substantive portions of the law have to be considered under the Article 10 process unless there are criteria like unduly burdensome, etc. So,
I'm sorry.
Sure.
Are you raising this, though, as an argument for why it should be considered review of the PSS or eligible for PSS funding?
Yes, because unlike most processes, and unfortunately, and hopefully in the future, there will not occur a situation where the PSS is prematurely submitted before the towns have completed their review of their local regulations. And I think that creates a unique circumstance. And our function, my function, was to try to advise the towns what the Article 10 process means to the local laws that they were adopting, and how it was necessary to sort out what would occur for a small project, what would occur for this project such as signing board. So it has been part of the process of preparing the town and orienting the town to the fact that there's a different process than the process that occurred 5 years ago. And
I'm not sure what you're talking about.
well, 5 years ago, this
ago.
project would be reviewed entirely by the town and the environmental impact.
Oh, you're talking about SECRA versus Article 10.
That's correct.
Oh.
Okay. So I just wanted to point out that
SECRA is State Environmental Quality Review Act. Apologize. Go ahead.
That's right. So anyway, I was just trying to to point out that it does facilitate the Article 10 process. This did occur after the May 4th submittal, and it was in knowledge of what was submitted initially by the PSS that the advice given to the town was consideration of that advancement of the Title 10 process. The last point I want to make is that you brought up that it was equitable, perhaps, for the town to receive the money. First of all, I just want to point out that it's the 50% is a minimum, not a cap. And I already mentioned that the county support the submittal by the county. And last but not least, if you look at our submission initially, we stated we were unaware that there was any formulation to other groups or that they were going to actually apply for funding at the time. So it was an effort to glom all available funds. It was with recognition that even that amount of funds for any municipality participating in this process is insufficient. Thank you for entertaining me.
Okay, I hope I didn't mean, I mean, I hope it didn't sound like I was saying you were trying to grab all of the money or glom all of the money. That was not my intent. It was just clarifying that your request initially was for all of the money.
Oh, no,
right?
I immediately
So,
regretted use of the word glom.
so if that's the way you took it, that was not my
No,
intent
that's
at
not.
all.
I just
was
wanted to have an opportunity to read it and for the code examiner to understand what the motivation of the town in making that.
Okay. And I just want to, I guess, be clear that you're not, or are you asking me to reconsider because I think I did say perhaps 50-50 split. Are you asking me to reconsider that in light of your argument?
Considering the submittals on behalf of both host communities and the host county, yes.
And what would you propose?
What would I propose?
If you were to do an equitable allocation as between towns and local parties?
Well, right now we don't know how many parties we have, and whether they'll be able to come back to you after the break with the idea of cooperation. So I don't think it's my role to do that.
If they cooperate, there will be one local party, one person, I guess, administering the funds. Because that, I mentioned this for the town, but the same would apply for any local party. If you are awarded funds, you have to have a personal federal identification number because you'll be required to enter a contract with the state. Again, you have to submit invoices and provide reports just like any other party. Someone has to be able to review that. So hopefully that has been considered as to who is going to be doing those reviews. Obviously, the person who is billing should not be the person reviewing the invoices and verifying that they're accurate. I think there should, I say obviously, but it seems there should be some separation. There are reporting requirements, and no money is dispersed until the work is done and those invoices are provided and the report. So it also may help, I think, because very often we've had situations, for example, where we've had an individual request funds as a local party, but generally an individual's federal ID number is their social security number. They don't want to provide that usually to the state, so sometimes it's helpful if a group or sometimes the law firm will let them use their federal ID number. It helps in terms of the administering of the contractual part of an award of funds. Hopefully that was clear to people, but so in a situation where there is one other local party and there are two towns, what would your proposal be as to an equitable allocation?
Well, I don't mean to be evasive about it, but I think all parties felt justified in their submittals. And I think you have to look at what contribution the other parties will bring in a specific field, and then make your own determination whether that's enough, that's missing, it's necessary. Unfortunately, you're in the solemn position of making those decisions.
Can I do one statement?
I'll let Ms. Britton
Yes.
be heard, and then Ms. No, thank you.
Originally, I was going to be the one applying for the intervenor funds, as we had probably 60 or 70 people sign on that said they wanted me to represent them. And the reason we did it is we want to work with everybody. Okay, we all have the same goal. The reason that we did it was because for the 4 experts that we can get to cover the 4 different sections, we can get it at a very reduced rate. One is almost free because we've done so much work for them. They will in return do it for us for, you know, very small amounts. So it's for the people. You know, we're not fighting against the people. These are the nationally known highest experts dealing with this right, you know, at the moment. And we've been doing it since 2004. But because I had some health problems, Colin did it instead of me doing it. But that's the reason why we wanted to, because we can get a lot more for the money. You know, I mean, if the attorney understands that, you know, because Rick James doesn't work for $4,000 usually. You know, Mike McCann, he told me, I did a presentation in October here, and with his world appraiser employment, he told me, he said, I know they're not going to get big intervenor funds because they're smaller towns. He said, but Ann, for you, I will take whatever's left. If there's any left, I'll do it. So we figured it would be to everybody's advantage on our side to, you know, get these interveners. And if we ask, they will do it for, you know, whatever there is.
Thank you.
In all due respect, I kind of disagree with the comment that Rick James will not do it for $4,000. I talked to Rick James. I've had a conversation with him. I received a specific number based upon the scope of services that were provided. She can be on the record to say that otherwise, but I just
No, I
like
think
to
I think the way I took that was, if you look at their original request, the proposal was to just have their 4 experts split the $17,500, which comes out to about $4,300. That's all she said.
just want to make sure that was clear.
Okay.
I do have a
I'm not trying to speak out of turn, but when you look at the town's request, they also have a request for a sound consultant, Mr. James Cohen. So, you know, that's included in theirs. And I'm not sure that the CCRP people really need to have Mr. James review the scoping document now, to be involved in stipulation. Just a point of clarification. I don't know if the
Colin works for the developers.
Okay. Thank you. Yeah.
During break, I believe I'll speak to the clients and she'll provide me the information to put back to you, but I think they are open and willing, and if there is something that we can consolidate even with the towns or something, if it's going to branch off to say we have noise, we're just going to have noise and opposition, just like you stated, that we're not going to have recurring charges for the same review. I think that's something that we may be open to, and I'd like to work together, obviously, with the town, as efficient as possible, spend the funds as much as we possibly can.
All right, so we're still going to take a recess. Why don't you maybe take that opportunity to talk while we are at recess? We'll be back in 10 minutes. My own rule about electronic devices. I need the calculator. That was not on the record.
No.
All right, so back on the record. We took a brief recess to both give ourselves an opportunity to consider what we've heard today, and I think also to allow the 2 local groups that have expressed an interest in participating to discuss. So before we announce sort of where we are, Did you want to report back on your discussions at this point, or would you prefer to?
Yes. So I had the opportunity to speak with the Parishville Hospital Alliance, or PHA, referred to, and both groups are in agreement to work together and would like to work together moving forward. With regards to the funding, you mentioned the need for a federal ID number. My law firm would presumably continue on with this project in representation of both parties, and we would provide our federal ID number for that if necessary. We would also like to continue forward with Rick James and James Wiegand. So with those two experts and current law firm being retained for the same services provided within our request.
So within the 17,500?
Yes.
Okay. You just made that a lot easier, actually. So thank you very much. I do think that this will really, I think, benefit everyone and give the local parties more of an opportunity to cover more of the issues that are of concern to them. I do want to note, though, what we've decided is to, we are going to do the split, 17,500 for the municipalities and 17,500 for the local party. We do think that that is equitable. We know that there's a lot of competition for limited resources, but I know the towns probably won't be happy with that, but I hope that everyone will work together and try to make those funds go as far as they possibly can and work towards that goal. So one of the issues, though, is that I will still need either proposed or actual contracts from CCRP. The other clarifying question I had, I guess, is who is the person that will be reviewing the invoices and
we do have a treasurer with the CCRP,
okay,
and
great.
I guess
Right.
I would have to review that with both parties to make sure that that person is okay to review for everyone.
Okay.
But that would be the person.
Okay. So with that, our determination is that we do want to do a 50-50 split between municipal and local parties. That our understanding is CCRP and PHA will be working together, and that award for CCRP/PHA is for the experts and purposes that you identified, and for the town, it's for your noise expert and your legal services that you requested. Same caveats that I mentioned initially, it has to be for review of the PSS or participating in negotiations of stipulation, should not predate the date of the PSS's filing. Other things. We will do a formal ruling confirming this, but I believe, I hope everyone knows that what we needed to do here was at least make some initial awards so that people can start to participate in the stipulations process and know that they have some source of funding. The other thing I should remind you, and I mean, it should follow, but we obviously cannot approve anything more than what we've awarded. So you'll have to make sure you monitor your expenses and do not submit, don't go over that, because we won't be able to, there will be no money to disperse for anything that exceeds your bill. Are there any questions?
I do have one question. So with regards to providing the contracts, now that our firm will be representing both CCRP and the Parishville Hospital Alliance, is our existing retainer with CCRP sufficient for the funds, or would you request a new retainer to be provided?
I don't think you provided me any retainers, did you? Did I miss it?
I don't believe there's one in that application, but we do have a retainer with CCRP, a copy of a retainer at the firm. But I want to know, would you like us to execute a new one? Is it necessary to execute a new one with both the Parishville Hospital Alliance or just with CCRP? Make sure it's proper.
I would prefer the new one. It doesn't have to be elaborate. Again, it can be proposed or actual, but just we're trying to tie up the loose ends here, and we need what the regs require. How quickly do you think you can file that? Not to put you
Tomorrow.
too much on the spot. Tomorrow? Okay,
Nothing
great.
I won't be back.
Any other questions on that portion? I believe you indicated that you had some statements or something with regard to the stipulation process.
Yeah, I just wanted to do a couple things, if you don't mind, Your Honor. Thank you for listening, but we will file a notice of the steps with the DMN so that everyone gets notice with that intent for people to advise us if they want to be involved. We will then have written drafts and electronic documents sent out so that there isn't a need to have 10 face-to-face meetings. When we get closer to what we think is a final, stipulation, then we may have a face-to-face meeting. I think that will clarify and help identify issues and save people time from travel. One point of clarification that we wanted to talk about was, so now we have one local party, and we have, I don't know whether there's 10 members or 100 members, but be that as it may, one thing that we thought could slow down and impede the process is, if you're a member of that group, will you adhere to one person, Brian, or whoever that is, be the spokesperson for the group, or are you going to then, if you're a member, be allowed to be sitting at the table, so to speak, on your own as well?
How likely do you think this is going to be a major issue? Because
I don't know if it's going to be an issue, but just at times we have seen that come up in other projects where you're a member of a group, but then you're also submitting, trying to you have a board, you're on the board, you're a member of the board, you're a participating member of that group, but then you're also submitting different documents, different comments on your comments are different. I shouldn't say comments, but different aspects of that stipulation.
I guess I'm not anticipating that this will be a major issue, but you want to be
just
heard? Because, for example, I guess maybe I'm thinking too that perhaps Brian might want to come with one individual one time on the phone and possibly a different individual.
Fair.
It may depend on people's availability, because a lot of other people who are desiring to participate in this have other jobs and other obligations, and so my thought is that they will likely look to whoever the representative is that attended that meeting to disseminate information to them, but I wouldn't expect, and please correct me if I'm wrong, that 91 people will show up for every single meeting. I just don't see that happening, but
that's a fair point. If Brian wants to have one or two people with him, that's perfectly reasonable. What we're concerned about is, Brian submits drafts, changes to stipulations, and then one of his members submits additional drafts.
Yeah, I would imagine that they're going to work through that process, but I don't want to speak for you. So.
No, certainly. It'll just be myself. Just to clarify, I think, just to make it clear, if we do have a call, I think just for out of character, if I'm not there to have people with me at the meeting, I may have them on the call, but I would speak.
Oh, yeah.
And maybe I may need them to chime in if they're not in the room with me.
Sure.
But with regards to the other portions of this, especially with the website, I think comments, obviously anyone can submit comments, but I think filings will primarily come from my office with me counseling with each of the clients, respectively, prior to that filing.
Good.
If that clarifies for you.
Yeah, it does. Thank you.
The other issue, I guess, is the timing, because there was a request for an extension and it was granted. So the applicant's response is currently due, I believe, January 10th?
No.
Or I'm sorry.
Okay.
January. July
That was
10th.
our next question for you, Your Honors, is due to the holiday next week, we're concerned about that date, July 10th, and we wanted to request an extension to July 14th to give us some time. Wasn't sure, that's our request, if we can go to the 14th.
I'm going to recommend that, well, I think you need to submit it to the secretary, because the secretary is the one that granted the extension in the first instance. And I would just do that on DMM so that everyone knows that you're making that request, including people that perhaps couldn't come today. I'll let her know that it's coming, and we'll try to turn around on responses as quickly as possible, but I can't rule on that right now.
I understand. I just wanted to let you know that was one of our positions.
Okay, and would that then mean, I guess I just noted the difference in timing, because obviously it would, I think, would impact when you would want to initiate the actual stipulations process, I have to make some statement that it is now time or possible for you to do that. But I wanted to acknowledge that there's that lag. We don't yet have the applicant's response because of the extension that was granted. It seems like that would be helpful information for anyone who's interested in participating to know what your response is to their comments before you go into stipulations. So I do want to say that that process will initiate, but I also want to recognize the fact that we don't have the response yet because of the extension that was granted.
Okay.
So,
our intention would be that we would file the response to comments and then submit a notice to the EMS indicating that we were starting the stipulations process so that the response to comment was before the other parties, before we proceed.
that seems to make more sense. So I guess I will announce that the stipulations process will be initiated with that understanding. Obviously, there will be some delay with respect to waiting for that response, but we'll also confirm the award of intervenor funding with a written ruling, but I don't think we have any other business to conduct with respect to this particular conference. So I do want to thank everyone for coming out and for your time and dealing with the strange weather getting here. I really do appreciate you showing up, and I want to thank the town for the use of the facility. And with that, I will close the record for now. Thank you very much.
Thank you.
Thank you all.
Thank you.